Welcome back to Court TV Live. We are following a new case this morning, the tricked into an abortion trial. Unsettling facts here. Robert Kawada is accused of poisoning a woman that he was dating who got pregnant, and that those poisons caused her to have a miscarriage. He's in court for a probable cause hearing where we're likely going to hear a lot of details that the prosecution has in their case against him. The judge is calling him up to the lectern now.
Scheduled for probable cause?
Yes, it's on for the first probable cause date. Your Honor, the comment's not ready for probable cause at this stage.
Is it the second?
It's the first date we've actually come into court, Your Honor. The first date, Attorney PTO did not represent Mr. Kawada at the outset of the case. He was represented by Attorney Kawada. Subsequent to that, Attorney PTO did file an appearance on behalf of Mr. Kawada. And so then the original date that had been set with Attorney Lev was not a good date.
It was advancing my request, Judge.
So this is the first date we've been back before the court since Mr. Kawada's reign.
And just so everyone's clear on it, my name is Mr. Speaker, I represent Mr. Kawada, and we're ready for probable cause at this point. And just so the court understands, what we call is 11 pretty serious charges against Mr. Kawada. That's my understanding at this point. They don't even have medical evidence that the producer that even asked for and they're charged with finding poisoning. And I frankly don't know how they can make those allegations with no medical evidence. But here we are.
Well, I don't know, right? I mean, perhaps there's an admission. I have no idea. But I assume this is something that you intend to indict for the grand jury?
It is, Your Honor.
So, considering that grand jury investigations, right, are not public, I don't know what they have or what they're doing.
But Judge, we're here today ready
I
to
understand you're ready, and I understand you're likely objecting that
We are.
to a continuance. I'll hear from you.
Thank you, Your Honor. And as Your Honor's already alluded to, there is, the Commonwealth is utilizing the grand jury to investigate this. There is additional investigation that needs to be completed. As Attorney Speaker has already alluded, these are very serious allegations against Mr. Kawada. Commonwealth takes that allegation very, very seriously, and as such, we take the investigation very seriously. I'm asking for additional time so that we can complete that investigation through utilizing the grand jury to obtain necessary information relative to the charges that the Commonwealth has brought against Mr. Kawada. This is the first probable cause date. Mr. Kawada is not in custody at this point, so I'm asking for an additional probable cause date so that we can provide that additional information obtained through the use of the grand jury and come back before this court either with indictments or an update as to the Commonwealth's investigation.
Your Honor, may I hear? Of course. Thank you. So we filed the discovery motion back on June 14th of 2024, looking for some specific discovery in anticipation of this probable cause hearing today. Commonwealth still hasn't responded to our discovery motion. I expected that they would give me some discovery today. They have not, nor have they even filed a written response to my discovery motion at this point, Judge. I only have the initial arrest report, and that's it. That's all I have in this case. I'm told that there are there's other discovery out there, but I don't have access to any of it at this point. It's impossible for me to try to investigate this case without additional information. I have filed, Judge, 2 motions to preserve. I don't know if you want to get those at cyber or get them in open court. I don't think that as to the video, the Commonwealth has any objection to preserving. I think they do have an objection to preserving the alleged victim's cell phone.
So I'm reading both of those motions, and when I read them, I'll decide if I'm agree with whether or not. But I'll first hear your response, Commonwealth's response to the request for discovery.
Yes, Your Honor. So at this stage, I would ask the court to take no action on it. Of course, Attorney Speaker provided all the discovery upon indictments. The Commonwealth was able to obtain those indictments through the grand jury. I certainly understand that at some point, discovery will be ordered for the probable cause date in the district court. But at this point, the Commonwealth's intention is to utilize the grand jury, and I'm trying to protect the integrity of that investigation. So there are, even from the probable cause statement, potentially other actors ask the board not to take any action on that. Of course, any Rule 14 discovery will be provided to counsel as the case continues. I understand at some point, of course, if there is going to be a probable cause hearing, counsel is required to get discovery on that. At this stage, this is the first probable cause date. I would just ask the court to take no action on it. If it becomes an issue that needs to be litigated, of course, the counsel will respond to those requests as ordered by the court.
Okay, so here's a question. First of all, how much time do you expect that you need? It's been 2 months, right? So how much more time do you need to at least make a decision of whether or not you are going to present indictment to the grand jury?
So I would ask for another 45 days, Your Honor. I think would be reasonable request at this stage. Of course, depending on how things transpire, there may be a need for additional time, but I just don't know that at this time. That's the hope that we can get that done.
Okay. Now, my second question is, other than, I think she's indicated that all she has is maybe the initial police report. Is there any other discovery that you can turn over that will not potentially affect I believe you described as the integrity of your grand jury investigation? Is there anything else that can be turned over at this point?
There may be some additional information that I can provide to counsel. I don't have a specific answer for this court today as to what that information, if that's something I can conference further with Attorney Scapiccio. If there are particular items that are of interest, of course, all of it's of interest to the defense, and I fully respect that. But if there are specific items that perhaps we can have a further conversation about, specific inquiries that counsel feels is more pressing, then maybe that's something we can agree upon. I'm certainly amenable to some discovery at this stage.
They don't get to be amenable. The Constitution says that my client's entitled to discovery. We filed the discovery motion, the Commonwealth has ignored it. What they basically told this court this morning is that this is just a holding place for them. The charging in this district court is just a holding place for them to get to the indictment. That's not what the SJC has said about probable cause hearings here in the district court. They've said they're now real things, that if we're ready for probable cause, we should hold a probable cause hearing in this case.
Not that they were ever not real things.
Well, just saying, not that they were real. I'm sorry, that was the wrong language, Judge. I apologize for that. They weren't held very frequently, I'll say, in the district court. And what the SJC has said is, no, a defendant's entitled to have a judge make a determination if there's probable cause in this case, not to be able to have the Commonwealth have complete control over the case for the first 90 or 120 days, where we get nothing. That was my whole purpose in filing the discovery motion well in advance of even the first hearing date. To be able to make sure that we had this discovery necessary. Now, I understand the Commonwealth says that they want total control over this case, but that's not what the rules say. That's not what Rule 14 says. This is mandatory discovery. I don't understand how they can't produce anything. Videos that they have, how are they going to do
So I think what I heard him say was that he thinks there was additional discovery that he feels can be provided right now, in his words, without compromising the integrity of the ongoing investigation. That's what I heard. Okay, so, but go ahead.
So medical records are medical records, Judge. They can't be faulted, they can't be amended, they can't be edited. They should be turned over in this case.
Well, we've reached the top of the hour. We have to hit the pause button, but it sounds like this probable cause hearing may not go forward. The state asking for more time. The defense saying you don't even have medical evidence to turn over to us. What's going to happen next in this case? We will watch it all together on the other side of this break. Good morning and welcome back to Court TV Live. I'm Julia Janae, filling in for Julie Grant. We are bringing you the case of Robert Kawada. He's accused of giving his pregnant girlfriend medication disguised as iron pills that ultimately ended her pregnancy. Kawada and his girlfriend were dating when she became pregnant, and he allegedly offered her these pills and vitamins that he called them allegedly vitamins. He's pleaded not guilty to the charges against him. Let's get you into live court. We're hearing arguments between the defense defense and the state. The defense saying that the state hasn't turned over any medical evidence, and they've requested that discovery in this case. It doesn't sound like they are going to be having a full-on probable cause hearing today, but it will be up to a judge. Let's go in.
How is that going to in any way impair the integrity of the grand jury? Videos that they claim they have. How is that going to impair the integrity of the grand jury?
I don't know anything about it.
So, you know, for them to stand here and say there might be some things, I don't think that's good enough. I think they need to tell us right now what they're willing to turn over and have a conversation with this court as to what they're not willing to turn over, because they want another 45 days, which we would object to, Judge. They've already had 2 months to put this case in front of the grand jury. It's probably a 2-witness case, and they haven't done it in 60 days. And so I don't know what the holdup is. I don't think that there's that much of a backup in front of the grand jury that they can't get grand jury time in 60 days. They understood we were coming in here. They understood we were going to be ready for probable cause. And they understood that we were looking for discovery. And they want to come before this court and say, no, we're not going to give them anything because they're entitled to that when they get to Superior Court. That's not what the Constitution says. He's entitled to investigate his case when they've levied these charges against him. And we can't do that without any evidence.
Okay. Thank you. You have filed something and you made these reference to be seen at sidebar.
Yes.
I can read those motions. Will it be self-explanatory as to why they should be seen at sidebar?
Because it involved the alleged victim, Judge, that's the only reason.
Let me just read this. Is the motion for
That's correct.
The second is entitled ex parte motion, conservation of the video.
I've already given that to the couple, they understand.
Okay, that's what I was wondering.
Yes.
Why it's ex parte?
Originally, I filed it because I wanted it preserved, Judge, but we've had a conversation, Collins doesn't have an objection to preserving
That's correct.
that.
Okay. So, I required with the detective side of the case, I think all of it, I'll confirm for sure, but we were interested in the same video, so we made efforts already.
Okay, so,
And I'm not asking at this point that it even be turned over, just that it be preserved.
no, I understand. So then I can allow that motion by agreement?
Yes.
Yes, Your Honor.
It's just a motion. I don't have a proposed order to sign under Article 17. Is that something we want to draft up and have you sign it, or do you think that this is sufficient?
It would just be for the preservation. So
Right, I understand.
to the extent that the Commonwealth has that under control, of course, we already have it. And then
You do have it.
there is some video that we have already, and I required of the detective regarding that video. I don't have an issue with the motion to preserve. To the extent that it goes beyond anything that we already have in our direct custody control, we'll make additional efforts in light of that motion to preserve to contain those items, third parties that was referenced.
So on 17 motion, right, it's not just what's in the care custody control of the Commonwealth. It goes beyond that. It is ordering this third party entity, in this case, I think it's Pennsylvania, right? It's ordering them to preserve.
Correct.
So I can just allow this motion, or if you want to draft up a court order of, under Rule 17, or have it go.
I can do that. I can do that. If you can allow the motion, then I'll send a draft order from the court as well. Thank you.
If you send it to the first one, if you haven't sent it to the
And it is going to be, if there's going to be a Rule 17, of course, it'll have to go to the third party as well, so.
Yeah, the clerk's office usually sends it to the third party.
So,
And your clerk's office.
I guess technically, to some extent, they have a right to be heard. But,
I don't know that they have a right to be heard on the preservation order, Judge. I think they have a right to be heard on the document.
okay, well,
But the preservation order,
I think to make sure that the,
it will say preservation.
that it says that, okay?
Yes.
So at this point, I'm just indicating on your motion is allowed without objection, and
Thank you.
and I will sign that.
Yes, Your Honor.
Okay?
And I'll get that to you by close of business today.
That's good, and I'm here for the rest of the week, so Hartman's not in today. So the motion, the preservation of the is there an objection to that?
So for one, I believe it is the first phone number that's listed. No, I don't have an objection to that. In fact, we have that. That's already done. So that can be allowed as a first number. The second number, I'm not sure that is a second number to preserve. So that's why I expressed to council my hesitancy to be ordered to preserve something that perhaps does not exist. So that's what I'm concerned. There's no affidavit. There's an allegation just made in the heading of the first paragraph of the motion regarding the second number.
So Judge, with respect to the second number, it's my understanding based on information that we've developed that there were actually two cell phones. The one that the Commonwealth has, which my understanding they told me today that they have extracted some information from that cell phone. I'm asking for a mirror copy of that cell phone to be preserved. So to the extent they haven't done a Celebrate mirror copy of that first phone, I'm asking that that be done. Because what I understand from the problem this morning is that they have taken some things off the phone, but they're not sure if they've actually made a mirror copy of the phone. We want to be able to, at some point, have a discussion with the court about whether or not we get access to it and what our expert can actually do in terms of a search of that cell phone data. With respect to...
Is there an objection?
No, there's no objection in that. I'm following up on that. Correct.
And as to the second phone, it's my understanding, Judge, based on my investigation, that there was a second phone in use. We provided the number of the second phone that we believe was in use. Almost taking the position that they don't know. I don't think they've asked whether or not she had a second phone. So,
Mr. why don't you file an affidavit? I'll put this on for a very brief call.
sure.
Okay? And if there is, I mean, for all I know, this could be the clerk's phone, right? So without something more in the form of an affidavit, I can't file this. The first number, I think, is it's agreed to, and there's representations that are made that this is the alleged victim's cell phone or something that they have actually used. So with respect to that second number, I'm not going to make more on that unless and until an affidavit is filed. So I can put it on for a second call and you can draft something up, or I can allow it as to the first phone number and you can file something in the future. But again, you're going to be waiting 45 days to 2 months to file that motion. Continue your time to file it.
So I'd rather have a second call, Judge, and we can get that.
Anything on that file? So I'll hear you on that issue after affidavit obviously signed by a person with personal knowledge.
Yes.
And we'll take that.
Yes.
So in the meantime, perhaps the two of you can be thinking of a date that's agreeable to you. Your objection will be noted. And haven't made a decision. I want to hear the rest of the case. But if I am to allow it, think about a date within 60 days, and that's agreeable. Okay? And any objection will be noted for the record and we'll get the process.
Of course.
And any continuance over the defendant's objection.
Of course.
Thank you.
Yeah. 3-second call, let us know when you're ready.
Thank you.
The state wanted this probable cause hearing to be continued. The defense objected, and the judge did agree to continue it. Let's bring in our trial attorney who is standing by, Cannon Kearney. Cannon, good to see you. It does seem like the state doesn't have, or the Commonwealth, we're in Massachusetts, doesn't have their stuff together. They are mentioning a grand jury that they are going to be convening. They, according to the defense, haven't turned over medical evidence, video evidence that's going to be coming out in this trial. Can you explain for us why a grand jury would be necessary in a case like this one?
Well, good morning, Julia. Essentially, the grand jury is here to ensure that the charges that are being levied against the defendant actually have probable cause, or if there's actually a reason that a jury can convict. So if they're going to be bringing another grand jury, either they have other individuals that they want to be a part of this case, so maybe a co-defendant, or maybe they have more charges that they actually want to levy against the defendant. So for that reason, that is why they may convene with another group of people from his community to see whether or not the new charges actually have enough probable cause to get an actual conviction.
Yeah, often we see a grand jury before we even get to this point of the defendant being inside the courtroom. The fact that he is out on bond is a determining factor, helpful factor for this judge in continuing the probable cause hearing. We're talking about a unique case, though, here, Cannon. We're talking about a case where he's accused of giving his girlfriend these pills so that she could have an abortion without her knowledge and resulted in a miscarriage. This is going to be a challenge for both sides.
Definitely. First and foremost, you have to essentially improve intent. Yes, he was giving some form of medication or some form of vitamin or some form of supplement to the victim, but did he know that this was something that would essentially be an abortion pill? Did he know that he was essentially stopping her from her ability to make a choice on whether or not she wanted to have a child? All of these things will have to come to light, and the prosecution will have to flush out that so that a common person, a juror, can clearly understand that this was his intent. And then you have to go into just the conversations, his bank statements to see if he knew that he was purchasing something of this nature, things that he communicated to her or other people. There will be a plethora of evidence that will be needed in order to get a conviction. But it seems as if the state of Massachusetts believes that they have a case.
Yeah, and I think the added thing that the prosecution will have to prove is that what he did actually did result in this miscarriage. That's the part that the defense wants them to turn over, that medical evidence. And I think a lot of doctors will say that they can't say for sure what causes a miscarriage to happen. So we will see what kind of evidence in this case they have. And when that probable cause hearing does happen, we will, of course, bring it to you live.